Thank you very much, Mr. Moderator. Excellencies, ladies and gentlemen, I'm very honored to talk to such a distinguished audience and would like to thank the Ministry of National Defense of the Republic of Korea to have invited the ICRC to be part of this very important event. As underlined in the previous panel, it is important to distinguish cyber warfare from other cyber operations. The fact that I will talk only about cyber warfare does not mean that the ICRC favors the militarization of cyberspace, which was discussed in the previous panel, nor that we think that the answer to all cyber threats should be dealt with militarily. My focus on cyber warfare is only due to the ICRC mandate, which is to work for the faithful application of international humanitarian law when and if and when states decide to resort to cyber warfare. So what do I mean by cyber warfare? By cyber warfare, I mean cyber operations against or via a computer or a network through a data stream when such operations are conducted in the context of an armed conflict, within the meaning of international humanitarian law, IHL. A large proportion of operations refers to a cyber attack are in fact illicit information gathering operations such as industrial espionage and occur outside of the context of armed conflict and they are not governed by IHL. Maybe you wonder why the international community of the Red Cross is concerned by cyber warfare. We generally follow the development of new technologies and their use or potential use in armed conflict, and the development in the telecommunication field is no exception in that regard. The ICRC is particularly concerned by cyber warfare because of the vulnerability of cyber network and the potential human cost of cyber attack. If the network of a state are attacked, there may be a risk that civilians get deprived of basic essentials such as drinking water, medical care, and electricity. If GPS systems are paralyzed, there may be a risk of civilian casualties, for example, through the disruptions to the flight operations of rescue helicopters meant to save life. While the military potential of cyberspace is not yet fully understood, it appears that such attack against transportation systems or electricity network, or even attacks against dam or nuclear plants are technically possible. Such attack would obviously have wide-reaching consequences for the well-being, health, and lives of possibly hundreds of thousands of people. It is thus the role of the ICRC to recall that in an armed conflict, constant care must be taken to spare civilians and civilian objects. Indeed, cyber warfare is subject to international humanitarian law, just as any new weapons or method of warfare. There is no legal vacuum in cyberspace. This does not mean that it cannot be ruled out that there might be a need to develop the law further to ensure it provides sufficient protection to the civilian population, and that's something which will have to be determined by states. Among the questions put forward by the organizers for this panel is the position of states on the Tallinn Manual on International Law applicable to cyber warfare. The ICRC contributed to the group of experts that drafted the manual in order to ensure that the manual upholds the protection that IHL gives to victims of armed conflict. The ICRC generally agrees with the formulation of the rules in the Tallinn Manual. However, there may be exceptions. You have a couple of examples in my written presentation in the program. It's generally when we consider that the rules should have been stronger, more protective for civilians. The Tallinn Manual is a non-binding document prepared by a group of experts in their personal capacity. It's not a NATO doctrine. Though it is a regional endeavor and not a universal one, the ICRC welcomed the fact that such discussions took place, and we certainly hope that the manual can usefully contribute to further debate among states on those challenges. The ICRC welcomed that such discussions are also taking place in Asia, and we commend the Ministry of National Defense of the Republic of Korea to have put this very important topic on the agenda of the second Seoul Defense Dialogue. The ICRC will continue to offer its expertise in IHL to address the challenges raised by the application of IHL to cyber warfare, and I will shortly discuss 4 of those challenges. First, anonymity. In most cases, it appears difficult, if not impossible, to identify the author of an attack. since IHL relies on the attribution of responsibility to states and to other parties to an armed conflict, that creates major challenges. If the perpetrator of a given operation cannot be identified, it is extremely difficult to assess even whether IHL is applicable to the operation. It appears, however, that the answer to this challenge might not lie in the legal field only, but probably predominantly in the technical field. Second, do cyber operations amount to use of force triggering the applicability of IHL? There is no doubt that an armed conflict exists when cyber operations are resorted to in combination with traditional kinetic weapons. However, when the first or maybe the only hostile act is a cyber operation, can this be qualified as constituting an armed conflict within the meaning of IHL? Let me clarify that I am not discussing here whether cyber operation alone could amount to a use of force or an armed attack under the UN Charter. These are definitely very important questions, but there's an issue of use ad bellum, which is outside of the ICRC mandate, which, as you know, is limited to use in bello. I am talking here of the applicability of IHL as it is defined in the Geneva Convention and additional protocol. To take examples, while nobody acknowledged responsibility for operations such as Stuxnet operation in Iran in 2010 or the cyber attack in March in Seoul, which have been described before, if the source of this attack could be ascertained as being state, that would raise the question of whether they would have triggered IHL applicability. Stuxnet, as you know, resulted in physical damage to the centrifuge, while the March cyber attack in Seoul did not directly result in physical damage. The ICRC believed that defining the type of cyber operation that triggers the applicability of IHL, for example, whether it needs to create physical damage or not, in the absence of any kinetic operation, will be determined only through future state practice. Third challenge, in situations where it is established that IHL applies, the question arises of the definition of cyber attack under IHL. Attack is a cardinal notion for the rules on conduct of hostilities, in particular for the principle of distinction, proportionality, and precautions in attack. The Tallinn manual defines a cyber attack under IHL, and I quote Rule 30 of the manual, as a cyber operation, whether offensive or defensive, that is reasonably expected to cause injury or death to persons or damage or destruction to objects. End of quote. The crux of the matter, however, lies in the details, namely what is damage in the cyber world. After intense discussion, the majority of the experts agreed that loss of functionality of an object may also constitute damage. Our view at the ICRC is that if an object is disabled, it doesn't matter how it occurs, whether it's through destruction, physical destruction, or loss of functionality. This issue is very important in practice, as otherwise a cyber operation aimed at making a civilian network dysfunctional would not be covered by the IHL prohibition of directing attacks against civilian person or object. The March 2013 cyber attack in Seoul plainly illustrates the question. As mentioned before, they did not create physical destruction, but prevented the functionality of some civilian networks temporarily. So let's assume that IHL would be applicable to such an attack. And I don't say it was the case, but to reflect on the matter, let's assume IHL is applicable. Such attack would have constituted a violation of IHL because they would, they at least appear to have been directed against civilian objects protected against direct attack. If you take a more restrictive view of the notion of attack, if you require that there needs to be physical damage for the attack, that might imply that fewer rules and less precise rules would govern and therefore restrict such type of operation. The last challenge I will mention is the question of interconnectedness of cyberspace and the challenge it creates for the rules of IHL aiming at the protection of civilians and civilians' objects. There is only one cyberspace. The same networks, the same routes, the same cables are shared by civilians and military users. Interconnectedness of cyberspace might make it impossible to distinguish between military and civilian computer network when launching a cyber attack. If it if such an attack is carried out nevertheless, it would violate the prohibition of indiscriminate attack. Similarly, the use of malware that would replicate without control and damage civilian network is also forbidden. Furthermore, a party to the conflict must do everything feasible to assess whether the attack may be expected to cause incidental harm to civilians or civilian network that would be excessive in relation to the direct and concrete military objective. If such collateral damage is excessive, the attack is forbidden. But that raises the question of whether in cyberspace, is it at all possible to appropriately assess the incidental effect, including the indirect consequences of a cyber attack? Those 4 examples are just a short glimpse of the challenges created by the application of IHL to cyberspace. There are many other, the definition of cyber weapons, the geography of cyber conflict, the application of the law of neutrality. I can't discuss them all here. However, these challenges, in our view, underline the necessity to be extremely cautious if and when resorting to cyber attack during armed conflict to avoid harm to civilians and civilian network. These challenges also underscore the importance that states that would develop or acquire cyber warfare capacity, whether they do so for offensive or defensive purposes. States have to assess their lawfulness under IHL like for any other new weapon or any other new method of warfare. This is the only way to ensure that their armed forces and other governmental agencies potentially involved will be able to abide by their obligation under international law when resorting to cyber capabilities during an armed conflict. The fact that a growing number of states are developing cyber warfare capabilities, defensive or offensive, only reinforces the urgency of this concern. I thank you for your attention.